examples.
That's right. As the only U.S. immigration attorney on this panel, I'm going to really focus on that topic. In my work as an immigration attorney over the past few years, I have seen how oppressive regimes are actually manipulating the U.S. immigration system to persecute political dissidents seeking refuge in this country. They are utilizing our justice system to arrest and jail political dissidents. And the manner in which this is happening is quite clear. Law enforcement agencies, in particular Immigration and Customs Enforcement, or ICE, utilize red notices to target foreign nationals, many times asylum seekers, and to detain them and press for their deportation. The Department of Justice does not consider a red notice to be sufficient basis for an arrest. It does not meet the probable cause standard under the Fourth Amendment and really offers little assurance into the legitimacy of the allegations it concerns. Unfortunately, what we're observing in the immigration field is that ICE is treating many red notices as conclusive evidence of criminality, which have consequences on the basic rights of victims of persecution. And even worse, this blind acceptance of an Interpol communication without scrutiny can and often does turn ICE officials and our own immigration judges into unwitting agents of repressive regimes. I'd like to share with you some real-life examples of Interpol abuse that are currently processing through our immigration system. My client, a citizen of Russia, entered the U.S. with a valid visa and applied for asylum before the U.S. Citizenship and Immigration Services. His persecution claim is based on spurious and persecutory tax fraud charges lodged against him by the same tax office that prosecuted Sergei Magnitsky. He appeared for what was supposed to be a non-adversarial asylum interview before USCIS. Instead, ICE arrived at the interview and detained him. He spent 4 months in jail before being released on a very high bond. Interpol actually canceled the red notice, recognizing its illegitimacy. However, my client and his family had already suffered the worst effects of the red notice through the U.S. immigration system. Years later, his case continues to languish in U.S. immigration court. We filed a Freedom of Information Act request in his case, which revealed that ICE categorized my client as a danger to the community and a flight risk based on nothing more than the existence of the red notice. So in this very specific example, ICE agents and the immigration courts became tools in advancing bogus criminal allegations made by an autocratic government. There are many, many more examples. In another case, a U.S. citizen filed to obtain lawful permanent residency for her father, a citizen of Armenia. Her father was the subject of a red notice that arose from a private business dispute with corrupt Armenian officials. ICE went to his home and detained him. The immigration judge denied a request to lower an extremely high bond amount, and this was in spite of extensive ties with U.S. citizen family members and his eligibility for permanent residence. The sole stated reason for refusing to lower the bond amount was the existence of the Interpol red notice. In fact, a red notice actually decreases flight risk and makes travel a lot more difficult. Nevertheless, DHS officials and immigration judges alike consistently miss this point, all at the expense of the liberty of persecuted persons like my Armenian and Russian clients. I'd also like to point out that a recent survey issued by the American Immigration Lawyers Association, which has more than 16,000 members, uncovered many more similar examples of Interpol abuse in the United States. As my colleagues here have testified today, Interpol does serve a good purpose, and the built-in human rights protections found in the Constitution and subsidiary rules are sound, but they only work if they are properly applied. My recommendation is that part of holding Interpol and the Commission for the Control of Interpol's files to a more higher standard is requiring them to have greater transparency. Jurisprudence and reports must be published, and the organization must allow for more access to information and opportunities for advocacy, especially for persons who allege Interpol abuse. Within our own borders, we must do a better job at ensuring that immigration officials understand that the mere existence of a red notice, especially when it concerns an asylum seeker or affects the interests of U.S. citizens or lawful permanent residents, cannot be considered conclusive evidence of criminality. If the Transnational Repression, Accountability, and Prevention Act accomplishes even some of these goals, it will be a much-needed first step to address the problem of Interpol abuse and to prevent our justice and immigration system from being further manipulated by autocratic regimes. Thank you.
Well, thank you very much to all four of you for your excellent testimony. Let me, who testified about the, who can tell us how much the United States donates to Interpol each year?
I'm afraid I don't have the exact statistics, although there might be other people in the room who might be able to get the statistics for you. The United States, at least among state donors, is easily the largest donor to Interpol. But I don't have the statistics.
Okay. Well, try to get that
I believe
to
I do.
Okay, yes,
This is in part thanks to the research of Dr. Ted Bromond. It looks like the United States contributed 19.4% in 2019, 11 million euros, and this is compared to Japan, which is second, who contributed 6 million euros, and China third, Russia, then Turkey. So the United States is by far the greatest statutory contributor to Interpol.
when was Interpol formed?
I believe Interpol was formed around, I think, the 1930s. It's often criticized for the fact that I think there was German involvement or German leadership in the creation of Interpol at the time, but that's the historic origin of the organization. I think it's evolved considerably since then, obviously. It started very much, I think, as very much like a non-governmental organization, a policeman's club, and now it's a much more formal entity.
Was it abused during the run-up to Nazism in Germany?
I don't know about that. I mean, there's what we would say, though, that the phenomenon of red notices and diffusions and other the other tools of Interpol being misused to this scale is a relatively new phenomenon. Obviously, red notices have been around for decades, but it's relatively recent that they can be circulated with this much ease, and that's primarily due to technological developments, first of all, and also the growing understanding amongst states that international cooperation on police matters is absolutely crucial these days, given the global nature of security threats and crime.
No question, it's a vital tool. No question, it's being abused on a large scale. Who was giving? I'm jotting notes here and trying to juggle members who had to go vote. Who was giving us information? Was it you, Mr. Mann, about the number of red notices per year and the number of diffusions per year in the entire of Interpol?
Yes, I think the latest statistics were something on the region of around 13,000 or 14,000 new red notices per year, and about 50,000 diffusions, new diffusions per year. And those, I think, are just diffusions that call on the location and the arrest of individuals. I think it's worth mentioning at this point that the number of new diffusions issued jumped dramatically in the past couple of years. I think the Interpol would attribute that primarily to the increasing use of their systems for the foreign terrorist fighters alerts. But there are concerns that as there are better safeguards for better safeguards that prevent the misuse of red notices. Countries are turning to diffusions instead, which have a less stringent checking.
Okay, so well, tell us about that. Let's give the Commission and our friends listening worldwide those differences. When would you, and you want to jump in, Mr. Schenken, when would a country decide to go through the more difficult procedure of a red notice? What does that entail? And then why is a diffusion easier?
Well, I'll also defer, I think, to Bruno and to Sandra Grossman on these matters, but I would say that the concern that observers of Interpol have is that the diffusion process essentially sends the communication directly, so Interpol is acting as a middleman, but without necessarily a process by which it's a formal process by which that diffusion is reviewed.
So they don't vet the diffusion at
the moment of submission.
Right. I mean, there's some unclarity on this, and what would be ideal is for someone from Interpol to explain that to us in that much more detail. So the reason why countries would use red notices instead of diffusions is that red notices are meant to have a higher injunctive value. Red notices are meant to be more serious, and that's the reason why they use that, whereas diffusions are meant to be more informal, kind of casual variants, I suppose, in lots of situations. So in terms of how the two differ in terms of how they're being checked, with red notices, the information that eventually gets uploaded onto red notices don't become visible to other member countries until the request for the red notice is checked. So the country would send a request to Interpol's General Secretariat saying that they want to have a red notice disseminated and provide them all the details. That would be checked by Interpol, and then only if it's found to be compliant would that red notice be disseminated to all the member countries. Whereas with diffusions, diffusions start their lives off pretty much like emails, like just normal electronic communications between member countries of Interpol. And it is only after when that information is sent out that Interpol is able to review that information, and only after it's done that is it able to validate that communication as a valid diffusion.
And I'd just like to point out, the organization is supposed to properly vet red notice requests before they are sent out. The organization has very sound rules in its constitution, the principle of neutrality, the idea that any request by a member state has to comply with the spirit of the Universal Declaration of Human Rights. But what's nebulous in these cases is exactly how Interpol is going about the process of making sure that these requests comply with the rules, and clearly there are some significant gaps there that are allowing some of these requests to be emitted. And then, what makes the situation worse is that the mechanisms for then addressing illegitimate requests is extremely lengthy, inefficient. There's very little access for information. Victims, you can write to the Commission for the Control of Interpol's files to get a review of your case, but as someone else here pointed out, there is no appeal, and there's no opportunity. Sometimes you're not able to learn exactly the details of the allegation, so it's a very difficult process that leaves victims with little opportunity for redress.
Mr. Min, how on the CCF, that stands for Commission for the Control of Files. It's the body which handles requests from individuals seeking access to or removal of information from Interpol's files. how well is this commission staffed? How big is this commission? How many members and how many staff?
So the commission is structured in a way that it's divided into two chambers. One deals with kind of data protection issues, and the other deals with complaints. I think the division is 3-4. So there are 4, I think, commissioners, I think, in the complaints chamber. Is that right?
There's 3 commissioners in the supervisory and advisory chamber, and then there's 5. in the
5, sorry.
request chamber.
Sorry, thank you. They sit a few times a year to decide on requests and complaints. But they work with a team of, I think, around a dozen people in the, there's like a secretariat of the Commission for the Control of Interpol's Files who are there full time, and they're the ones who really do most of the legwork. But even then, I mean, I think what we hear from them, from speaking to the Commission for the Control of Interpol's Files, is that it is always a big challenge in terms of shifting through all these requests with the limited funding and staff resources that they have. So it was very disappointing that last year, in last year's budget for Interpol, it seemed as though the staffing had increased by 1, but the funding for the CCF had actually decreased.
Where is it housed?
It's in Lyon. It's basically next to Interpol.
In the most celebrated case that I know of, the case of Bill Browder, how is it that there's just not a flag anytime the Russian Federation submits a red notice on Bill Browder, that this is probably bogus and it's probably just a rehashing of what's already been determined to be invalid? Who wants to try that?
If I can just jump in there as well, I think the main issue about Mr. Browder's case is that these are diffusions, and for the reasons that we mentioned earlier, diffusions are notoriously difficult to check for Interpol because the information that forms the basis of diffusions are sent out directly between states. The real problem, I think, is that we can always delete red notices and diffusions after they've been disseminated through whatever means, through the Commission for the Control of Interpol's Files or whatever other means. But the frank reality is that in the policing context, I'd be very surprised if data was ever really deleted. Interpol, the data that's being circulated via and on Interpol systems is quite often transferred, and they are transferred into domestic databases. And Interpol might, for reasons that a red notice or diffusion is incompliant with its rules, delete that from their databases and ask other countries to delete copies of that information from their domestic databases, but there's a big problem with compliance. And it was quite telling last year, I think. A question was asked in the German Bundestag about how often the German police comply with Interpol's requests to delete red notices or diffusions. And the response that came back was that they delete the vast majority, but they don't delete all of them. Given that Germany's been particularly vocal about the misuse of Interpol, we found that quite interesting and surprising.
Let me just ask this, and unfortunately, they tell me there's a car waiting for me outside at 11:30 to take me to another meeting. So we're scheduled way too tight on this important matter, and I apologize for that. Is there anything in the Constitution or bylaws or procedures of Interpol to stop resubmitting these notices and diffusions? And are there any sanctions or penalties? Yes, ma'am, Ms. Grossman.
If I may, Senator Wicker, there is a possibility within Interpol to make preventative requests, and we have done that in cases where there are blatant human rights abuses. And also, I'd like to point out that in the Bill Browder case, Interpol did stop issuing diffusions and red notices against him in recognition of the illegitimacy of those requests from Russia. So there are some mechanisms where one is able to make this kind of a request. The issue is, too, that Interpol has very stringent rules on admissibility. It's an organization that is built to respond to the requests of member states for law enforcement purposes. And so when you as an individual are arguing that you are a victim of human rights abuses, you have to show that your request is admissible, and you have to know that, in fact, you are included on Interpol databases already. So there, again, while there are avenues for redress, they're difficult to access.
On the point about how they're able to prevent repeated cases of abuse on exactly the same case, we haven't had a very good answer very convincing, in my opinion, answer from Interpol as to how they do that. We've been given assurance that once a red notice, for example, has been found to be incompliant with its rules, they have systems to make sure that repeat attempts of red notice requests are refused. But there's also, again, there's a question about diffusions, which is not circulated in the same manner. But we have seen at least one example of that system not working. And that was about 2 or 3 years ago, where we had one individual who claimed asylum from a Latin American country. And once she did that and she got her refugee status, she contacted Interpol immediately to say, I'm very concerned that I might get a red notice against me. This is proof of my refugee status. Could you please block any attempts at getting a red notice? That didn't work, and she was arrested on the basis of a red notice in another Latin American country within a matter of months. So there is a big question about how efficiently that system works. In terms of what can be done in terms of repeat offenders, as in the repeat offending countries, it's well within Interpol's functions to restrict access to its databases to countries that are repeat offenders. My understanding is that doesn't happen that often, they have never. We don't know of any kind of specific examples of that being done, and this is partly to do with them being a membership organization and being sensitive to the opinions of its member countries, perhaps.
Mr. Cooley, I'm going to be chastised if I don't make this next meeting. Mr. Schenken made specific recommendations. Is he absolutely right on all of them? Do you support wholeheartedly what he had to say, or would you make any modifications or give some advice to us? And then I'll ask the other two also.
No, on the specific recommendations, I would wholeheartedly support those. My final comment would be a general one, which is many of these organizations that the Commission deals with on the international regional front, the overall change in the international context has also changed authoritarians' calculations. Right? There's a certain sense that there's a good faith nature to the protections that are in Interpol, right? That we're not going to abuse them for these sort of constitutional reasons. Once that good faith is no longer there, then there are all sorts of manners in which these safeguards and protections within the DNA of these organizations can be twisted and manipulated. So that's just my word of warning.
Mr. Min, were those good recommendations?
Is that in Mr. Schenken's recommendations?
Yes.
I do agree with Mr. Schenken's recommendations, yes.
Okay.
I agree with them as well. I would like to point out just one addition to your question about how much the United States contributes. And what I cited to was the statutory contributions. It also makes additional contributions on a per project basis to the Interpol's trust fund and special account. So I do have statistics from 2017. The U.S. Department of State supported projects through Interpol with a total value of 2.6 million euros. And then there are other projects, apparently a memorandum of understanding with the FBI, which results in payments of unspecified amounts to Interpol. So we're looking at least 13 million euros in US statutory and project contributions in 2017. So the United States has the possibility to influence what happens in this organization and to advocate that the organization utilize its best efforts to apply the rules that it has in the Constitution and in its subsidiary rules.
And I hope this hearing provides a bit of a push, among others that need to be made in that regard. Your testimony is that different organs of the United States government view these notices and diffusions differently.
Yes, Senator. My testimony is centered around the fact that the U.S. Department of Justice has a very clear policy that red notices do not meet our minimum standards for arrest under our Constitution. Nevertheless, that message isn't getting across to decision makers in our immigration system who are using red notices to target foreign nationals in the United States. And many times these individuals are fleeing persecution in their home countries.
Good information to have and something for us to follow up on. Let me just observe that this hearing is about a broad tool, about a broad subject, and that's transnational repression. My questions have centered in on Interpol because it's something that's so visible and so egregious. We have so many examples of that. It seems that we come down to the real problem here, and that is that there are a large number of members of Interpol, including some of our allies, who are frankly international scofflaws. And to the extent that we have to defer to these governments and take at face value what they send to us, that has become a real problem and a real abuse. And I, for one, am determined to be part of a solution to getting to the bottom of this and reversing that. Thank you very much for being here. Thanks to all of you for attending, and for, I hope, thousands and thousands of people who are participating with us live stream today. Thank you, and unfortunately, this hearing is adjourned.